you could be entitled to money from debt collectors for doing exactly what I'm about to describe to you that they're getting away with because people just don't simply know their rights. There is something that's called the 7-in-7 rule when you're dealing with debt collectors. And I've had videos about this, but I want to clearly define it so you'll understand how the Fair Debt Collection Practices Act clearly states how debt collectors can contact you. And this is something that's just a total misconception. And I'm going to talk about the remedies that you can get. There's different remedies, and one of the remedies is money. But I'm going to show you how to clearly define if if a debt collector is violating your rights according to the Fair Debt Collection Practices Act, regardless if you owe the money or not. They still have to follow the rules. So there's this rule called 7-in-7 rule. I've talked about it before, but I want to clearly define it. It means that a debt collector, and I'm just going to read the rules so you'll know. The rule states that a creditor must not contact the person who owes them money more than 7 times within a 7-day period. Now, let me tell you one of the misconceptions about that statement and what makes people not understand. Well, really, the Fair Debt Collection Practices Act and the Consumer Financial Protection Bureau, I blame them for not making this clear, because there is stuff that you can write in a book. There's laws on the books, there's rules, regulations, all that stuff. But when it's actually being practiced, it could be used in a different way that would look like it's violating, but it's not violating because it didn't mean exactly what they said. So let me tell you the first misconception that most people have when dealing with calls, and they specifically said here, creditors. A creditor can call you over and over and over and over and over again until that account charges off. Then it becomes a collection. So this is like a play on words. So the first thing I want to clarify, because they didn't clarify it, but this is the way that it is actually practiced. This is the way that if you were to think that your original creditor violated you with the Fair Debt Collection Practices Act, you would lose your case because they didn't violate it simply because your account was not charged off yet. Once it charges off, it goes into the 7-in-7 rule. If a debt collector buys your debt, it goes into the 7-in-7 rule. So to clarify, before I move forward, because I'm going to talk about what is considered a contact. But first, before I move forward, I want to clarify, make sure you understand that an original creditor, as long as the account is still on the open books accounts, that means that you maybe have missed some payments, but it has not charged off yet, they can still call you every day of the week. Call. Once it charges off, it will go into this 7-in-7 rule for collections. So now, the 7-in-7 rule, I'll read it again. It says that the rule states that a creditor must not contact the person who owes the money more than 7 times within a 7-day period. Also, they must not contact the individual within 7 days after they engaged in a phone conversation about the particular debt. So once it goes into a charge-off status, an original creditor or debt collector, they can only call 1 time a day. But once they engage in a conversation with you about the debt, regardless if you have any answers or anything, you just answer the phone and say, send it to me, whatever it is. They cannot call you for another 7 days. They cannot, once they engage with you. Now, let's talk about what contacts are, because this is where they're getting over because people don't understand what a contact means. They think that it might just be the phone. They call me, call me, call me. That's a contact. Here is the list of contacts: phone, text, email, social media, and snail mail. So if you get called, you get that would be one, two, three, four, five. That would be five contacts that they would have: phone, text, email, social media, snail mail. And they would have two more contacts unless they actually got to talk to you on the phone. What most people think that comes to mind is they may think about snail mail and they may think about the phone calls. Now, the snail mail is usually going to only be done one time. It's going to be one time. Some companies do it over and over. They'll do it once a month. But now just think about it this way. I don't want to say that this is a trap, but think about it this way. If they call you 7 times within 1 week, and then you receive that letter in the mail and it was post stamped for that same week, that means that there would be 8 contacts. Remember, a contact means that they just attempted to. Once they engaged with you, it goes down to 1. They have to, or they have to stop. So if they did one, Monday, Tuesday, Wednesday, they talk to you on Thursday, engage with you in a conversation, then they can't call you until another 7 days. It just, the cycle has to start over. So, but think about it this way. What if they called you 7 days in a row, and within that 7 day period of time, you got a letter in the mail about the debt? Now, I'm not talking about the first Dunning letter. To be clear, this is not about the first Dunning letter. Uh, what I'm talking about is if they're just trying to repeatedly try to, get you to respond. That would be considered a contact. The Dunning letter at the beginning is something that they're required to do before they even start calling you. They're supposed to. A lot of times, some of these companies skip it. So, to be clear, they call you 7 days in 1 week, and then they sent you a letter, not the Dunning letter, just a letter saying, notice that you owe this debt. That would be 8 contacts, and that would be a violation according to the Fair Debt Collections Practices Act 7 and 7 rule. That would be a violation. And you can play with it and look at any combination. It could be emailed, it could be 3 emails and 4 phone calls. And then they threw in a social media contact with a message in your social media. So whatever it is, it doesn't matter what combination. What matters is that if you can prove that they did it 8 times within 1 week, that you can document that they did it 8 times within 1 week. You can look at your caller ID, and if you can match it up to their number, and then you would obviously, if they sent you an email or social media contact, you would automatically have that information in there. So a conversation, to be clear, when you have that conversation with them, that week has to stop. And most reputable debt collectors, once you have that conversation with them, you engaged, they cannot continue calling you the next day. They have to start that cycle over again. But most debt collectors will do that on a 30-day cycle once they engaged with you. But some, depending on how aggressive they are, they will start back over after another 7 day period passed after that initial engagement conversation, not just leaving you a voicemail. That's not an engagement. That would count as a contact. So now, voicemail does not count. Sending you an email does not count as an engagement. Replying back to their email is an engagement. Replying social media, just because they try to contact you on social media, that's a contact. If you reply back, that's an engagement. If they write you a letter, that's a contact. But if you write them a letter back, that's an engagement. So now let's talk about the damages that are the potential damages. The first potential damage is that it says here, if a debt collector is found to have violated the FDCPA, the consumer may be entitled to damages. These damages can include actual damages, financial loss suffered by the consumer, and additional damages for emotional distress. We all suffered emotional distress when we were dealing with debt collectors. The next one is statutory damages. The FDCPA allows for statutory damages even if the consumer cannot prove actual damages. As of my last knowledge updated, well, this here is just saying from the update that was done in 2022, statutory damages is $1,000 per violation. If you have an attorney participate, the attorney would be able to get the attorney's fees and any court costs. Violation of cease and desist orders. This is something that we've done a lot. I actually offer that letter if the debt collector has violated. You can just have a cease and desist, collect all collection activities if you believe that, where you didn't want to, have to go to court, or you didn't want to try to figure out a way to get them to pay, where you just didn't want to do the legwork on it, and you didn't find an attorney in your area that knows how to do this stuff. Then you just might say, hey, it just cease all collections. No 1099. You're just going to cease it, and you can't sell it to anybody. That would be what you would accept, and you would get that in writing also. And then other things that could happen if you do forward it to any agencies. They may, if a lot of them have added up, then they may seek to do some sort of massive fine and a class action to the debt collector for them doing that. So, all right, I want to make you aware of that. That's a 7 and 7 rule for collections. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website, yourthenumber3scores.com, to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early, grab my 3-pack of letters: statute of limitations letter for debt that is past the legal statute of limitations to collect, debt validation letter, and cease and desist collection activities letter. Now, I want to clarify something about the cease and desist collection activities letter. What this is, it's saying that if they cannot prove what is in that letter, provide you that information, you want them to cease all collection activities. It's not a cease communications letter, because that would not get you to where you want to be. You want to get some type of resolution on if they're going to be able to come after you or not be able to come after you. So that's what that letter is for. Link is below this video. I do ask for a donation on those, but it is up to you if you feel that I deserve it. Thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.